Welcome to the Practice Impossible podcast, where your host, Jude Pierre, MD, also known as Coach JPMD, discusses medical practice topics that will guide you through the maze that is the business of medicine and teach you how to increase profits and help populations live long. Your mission, should you choose to accept, is to listen and be transformed. Now, here's your host, Coach JPMD.
So today we're joined by Josh Keleske. He's an attorney. He's actually my attorney, licensed in Florida as well as Wisconsin. And we're going to talk about wills, trusts, estates, and financial planning that he does in his practices and his practice in Florida. And he counsels his clients through the estate planning and corporate transactions. And he's got over 20 years of experience, real world experience, and he knows how to bring money saving solutions to his clients and planning solutions as well. And he's helped me tremendously as well as some family friends. So welcome, Josh, to the Practice Impossible podcast.
Yeah, I appreciate you having me, Jude. Thank you.
So, should I call you Deacon Keleske or?
No, no. So I'm glad you brought that up. So as we talked about earlier, I'm going through the formation of the permanent diaconate in the Catholic Church. That's a 4-year formation. I am approximately 1 month into it.
Okay.
and basically the way it works is we've got 4 years of academic study, spiritual formation. It's a ton of work. I'm super excited about it. My wife and I went through a formal discernment through the diocese, which took about 6 months, 6-month application process. I guess I'm more than a year into it really, but formation is new. And the way it works basically is the church through our bishop will decide which men are called to the diaconate on behalf of the entire church. And, we're basically told that we are presenting ourselves for the possibility of the diaconate all the way up until the day before the ordination. So the church will decide, and my only goal is to say yes to our Lord. So we're going with it. And as I'm pretty much a type A, and I like to be in control. So for the first time in many years, I'm letting God take complete control, and I'm basically just saying yes and going with the flow. It's not my nature, but we're doing what we can. So I'm very excited. It's a great journey.
That's cool. I know you were pretty excited about it when I first learned about it. And I have to be honest, I was a little confused because I went to my fiance and I said, hey, you know what? Josh is actually, I think, going to be a priest. I'm like, she's like, he's married. What are you talking about? That's not how that works.
Yeah, the church. So the diaconate's been in the church, since the Acts of the Apostles, really. But it became transition deacon really for probably 1,000 years. So the first 1,000 years, there were permanent deacons in our church, and for a variety of reasons, it became transition. So from a man going into the seminary, studying to become a priest, he's ordained a deacon. Typically, 6 months to a year, he's a deacon, and then he's ordained a priest. And then with the Second Vatican Council, the church decided to restore the permanent diaconate, understanding the need for men that are living in the world to be a bridge, essentially, between the church and the world, where the hope would be that deacons can be a servant to the church, showing the congregation what we're all called to do, which is diaconia, which is service for each other, as Christ was. And then at the same time, to be able to be the bridge from the laity to the church, so that the bishop and the priest understand the needs of the congregation so they can be served properly. So it's an awesome role. It's one that can't be done by a man. It needs to be done by the Holy Spirit. And the man just says yes. So we're in the middle of that. I've got a lot of my brothers that are in the formation with me that, I think we're probably all just sort of wondering, like, what are we doing? And then we realize it's not about us. It's what God's asking of us. So we just need to accept that and know that we're not alone on our journey. So it's super exciting. I know I had a client, when I told them about it, they said, does this mean I need to find a new attorney? And I sort of laughed and I said, it doesn't really work that way. So our service to the church is we give it to the church, but we don't necessarily work in the church in an employment setting. So I'll continue to do what I'm called to do as an attorney, which I love, serving families, which is fantastic. 22 years now into it. And then if God willing, be ordained in 4 or more years or whatever it might be by the bishop's call, and then have a dual role, which is really cool. I'm excited about it.
Cool. So this episode, we're going to do something different. We haven't done this before with our guests, but because you're an attorney, because you have the experience, and because of the way physicians learn these days, we learn by scenarios, by cases and things that we come up against. And so I'd like to kind of do an episode where we discuss case scenarios. And, what would you do in certain situations? And I think we kind of discussed which ones that we would do this. I'm not sure which ones you're going to bring, but let's say you're a young doctor starting off and you've got no assets, no family or kids, and joining a hospital group with a fairly good salary. What would you tell that doctor that he needs?
I mean, I'd say at a baseline, I think one of the challenges that I run to with probably young physicians, but it's probably a statement that applies to young professionals, is that there's kind of a misperception that they don't need to worry about certain things like estate planning or even just, how they want to organize their finances until they're further along. And I find that that's a bit of a challenge because if they go down the road and it's the wrong road, it's costly and time consuming to back up and start over. So I would prefer to have my young physician clients assemble a team of advisors as a starting point that they would want to rely on. An attorney, financial planner, accountant. The needs that they'll have in the beginning may be modest, but they'll likely grow with time. So if they can develop a relationship based on trust, they'll be able to make the right steps. And then specifically to estate planning, usually my physician clients, maybe not so much newer physicians, but certainly my established physicians, will not only want to think about estate planning, which we'll talk about in greater detail later, they'll want to talk about asset protection. How do they make sure that what they have or what they'll accumulate is protected in the event that there's a malpractice claim or just generally, if I find that a lot of physician clients are concerned that they're a physician and if they get in an auto accident, they're just going to get sued just because of what they do for a living and the perception that they have a big income or lots of assets. So if a young doctor starting out, even with modest assets, understands that they can build from ground zero a proper asset protection plan built inside of their estate plan, it's highly functional. It's not necessarily complicated, but it's protecting themselves from the beginning. So, I will typically go through relatively easy asset protection strategies and then build it typically around an estate plan. And just really from the concept of an estate plan or that term is somewhat misunderstood. I've got a lot of clients, young doctors really in particular, that will say, well, I don't really have an estate, so I don't really need a plan. They'll say, well, I just need a will. And in reality, a will is an estate plan. It's a type of an estate plan. So, even a relatively simple will that says who's going to get someone's assets when they pass away, but also power of attorney to govern management of financial decisions. And then I'm never surprised with any physician client that I represent or anyone in the medical field, really, when I ask the question, do you have a medical directive? It's almost always no. And I think sometimes it's the old expression that the cobbler's kids don't have great shoes. And so just to think about having even a very simple healthcare directive, or there may be a few, so that decisions are managed by the people you decide. And so it doesn't have to be complicated. What I do figure out is you build what might be a simple estate plan. And then as someone's life changes, perhaps they get married, start a family, accumulate assets, then they just build on it. It's really no different than like having a starter house when you graduate from school. It's not necessarily the one that you're going to finish in, but it's functional. It's one you like, and then you can grow into something bigger.
Yeah. So you mentioned power of attorney, because I know the importance of a power of attorney, especially in my elderly population that, maybe widowed or not married. What does it mean? What is a power of attorney? I mean, for those that don't really know, and they think that that's more of a legal term that they'd give someone to, sign documents for them. So what does that mean to a physician who has no family or no spouse?
So it's probably a good starting point is to differentiate types of powers of attorney at just a high level. The first of which would be a financial power of attorney. The second is as a healthcare power of attorney. The adjective helps us. So the financial power of attorney is oftentimes very broadly written, giving someone the broad authority to manage financial decisions. It could be to take control of assets. It could be make an investment change, and really it could also maybe be to deal with a health insurance company. So, if I'm acting on my wife's behalf to manage a decision for her that's going to cost money, I may have to contact the insurance company. So having a power of attorney for my wife, or from my wife rather, would give me that authority. So we would usually recommend a very broad financial power of attorney, or at least as a starting point. But I can tell you there's many cases where we'll have a fairly limited power of attorney. And a classic example would be with a real estate transaction. So I actually did this with my wife when we moved to Florida 20 years ago. I was practicing in Wisconsin. I didn't really have the luxury of coming down to look for houses. I was trying to transition down. And so I gave my wife a special power of attorney to manage a real estate transaction on my behalf. Back 20 years ago, we didn't do things as digitally as we do now, but the idea was to give her a specific authority. And then once the authority was no longer needed, the power of attorney went away. Mm-hmm. We don't see that overly frequently, but it is a useful tool. We tend to recommend for clients to have a broad document, and typically it's broad also from the timing perspective. It's typically available right away for use, but then it almost never has an end date. And so in other words, I did give my wife a power of attorney, very broad, gives her all the kind of financial authorities you can possibly imagine to do things for me and really for our family. And it doesn't have an end date other than, the end date is when I die. So it's a living document. Mm-hmm. On the healthcare side, that term's obviously, a little easier to get your arms around, but it's just to make sure we manage medical decisions. Here in Florida, we often call that a healthcare surrogate, but some states use the term healthcare power of attorney, some healthcare proxy, but the concept's essentially the same, which is if I'm not able to manage a medical decision, I can give the authority to someone else to do so. And a little side note, which is something that all physicians learn about, certainly, is that I always include in a medical directive a HIPAA release. HIPAA, as you know, Jude, you've been in practice for a long time. It's been around since really 1996, although the privacy rule came into being in 2005. And really in the beginning, I don't think that was really enforced very well. So, I could go to the doctor, talk about my wife's care, and they were fairly liberal in giving information. The game's changed a lot now. So there's some fairly stiff financial fines if there's HIPAA breaches. So we always think about the healthcare power of attorney coupled with a release under HIPAA. And it's kind of intuitive. How can I expect my wife to manage a medical decision for me if she doesn't have access to information? So we're really just marrying up those two. So you would see that in a typical healthcare directive to do both, manage decision, but also access information.
So let's go back to the power of attorney for the finances, though. I had a patient the other day say, well, I have a child, I have some assets, I'm going to sell my house. But that child has had some legal issues, drug issues or whatever, not trustworthy to manage her finances should something happen to her. She was a little older. So can you assign it to someone else or an entity or a bank, or how does that work if you don't have a person to assign a power of attorney to do?
Yeah, that's a challenge. So the Florida statutes, in particular states are similar, contemplate the possibility of an institutional agent on a power of attorney. I have not worked with any in Florida. In fact, they all shy away from it. So we tend to look for people. I'm a big believer in thinking about who's close to you, like who's in the inner circle first. So, and because power of attorney is really predicated on trust. I'm giving someone broad authority to manage a financial decision. That's a big deal. Someone could take advantage of it. So we want to make sure we're smart about who we designate. But to your point, what do you do if your inner circle isn't as great as we would like it to be? There are certainly options beyond that. The one that I've used frequently in the recent past is to have professional fiduciaries engaged. So individuals who hold themselves out to act professionally on a power of attorney. They can do that also on a healthcare directive, but they're paid to perform a service, and they're held to a standard because they're a fiduciary. And if they blow it, we have recourse. Okay. I don't see that used frequently because when I bring up the concept, most of my clients will say, well, wow, that's a stranger. I don't know if I want a stranger having access to my assets. And so then they end up digging deeper and looking for someone that they trust. It could be an advisor they work with, I have some clients that will name their accountant. Some will name an attorney. I certainly don't volunteer that role. I don't wish to be in that position unless it's for a family member. But on occasion, we just have to dig deep. We look at who's around us that we trust. And having a loved one that's not trustworthy, that's unfortunate, but we have to then just search, okay, who else can we find that we would trust to have access to our financial information, but then also on the medical side, because it's a two-part question, really.
Sure. So let's go to the second case. This case that probably would mirror me. 15 years of practice. I had no will. I had no power of attorney. I had none of this about 7-8 years ago when we first met. And 4 kids. What should a physician have in place? And I think you answered that. You have to have the power of attorney, and the healthcare surrogates. But what are some of the horror stories you've seen in a doc or in anyone who's had that life where they have kids and they didn't have a plan? Can you share any stories?
Yeah, I think kind of big picture, but we can talk about a couple of cases I've worked on. But I mean, big picture is in the absence of any planning, we're relying on state law to decide what happens. Mm-hmm. And that's really in the context of someone passing away. But, and really an example that comes to mind, although it's not with a physician client, it's a very sad story. I handled a probate matter. A gentleman passed away, very tragically. He was married. He had 3 minor children. And he had a home, and it was in his name only, as well as some financial assets. So when his widowed wife contacted me, we went ahead and helped her transition assets from her deceased husband to her family. And she was shocked to learn that in the state of Florida, when that situation presents itself, that she was not going to become the sole owner of her home. And that's because it was just in her husband's name. So the Florida statutes dictated a very difficult result, which was she ended up becoming a co-owner of her home with her 3 children. So at some point in the future, when she chooses to sell it, they're all going to participate and they're all going to be involved in the sale. I would be willing to bet her husband had no idea that would happen. Huh. Had he known that, he may have done something different. Could have been the house would have been jointly owned, or I don't know what they would have done differently, but they would have done something differently. So it's essentially the statutes creating a result that's inconsistent with what a family member would want. And so the judge. So in that situation, the judge and the probate courts could not override that law, right?
Or this?
Yeah, I mean,
is that a law that's written in Florida?
Yeah, that's constitutional and supplemented by our statute. So
wow.
We have, and I've actually had 3 of those cases. Mm-hmm. One of which was difficult because the person who passed away had 2 children, one of whom was not the child of the widowed spouse, and they were estranged. So it created an unbelievably difficult dynamic. The legal work is not difficult, frankly. We can help them retitle it, but then they have to live with that reality, which is really difficult. So that could have been avoided with proper planning. And frankly, it's not very complicated planning. It's a matter of educating a client. And what I've discovered when those types of things happen, it's frankly either because someone wasn't interested in doing planning, they procrastinated, they didn't know they needed planning, or sometimes people go on the internet and do their own will, and they don't know these nuances. And so the DIY version of estate planning can create a big disaster. Huh. So staying away from all of that is really critical. The other one that's not uncommon, really, from a lack of planning, and I'm certainly not going to pick on you, Jude, per se, but just to think of someone kind of in your situation, an unmarried physician client passing away with minor children and no estate planning. The result is that the minors would receive assets through a court-appointed guardian, and when they turn 18, the minors will get will receive their deceased father's assets. They're all underage still, so that's not an issue. But the challenge is, especially with physician clients who have a high income potential, they often have other things like life insurance and so on, that you run into a situation where an 18-year-old will receive $1 million, $2 million, whatever it might be. And that's a recipe for disaster. I haven't met too many 18-year-olds that are capable of managing assets. So that situation is avoided by having an estate plan. So it's whether it's a last will and testament or a revocable trust, just outlining what we want. It's not unusual to write a plan. And I'll take myself, my wife and I have 2 children who are minors. If we have a plan that says when we're both gone, everything for our children is held in trust until they reach a certain age, I've overridden the Florida statutes. I've decided what I wanted instead of letting the court decide. And that's not rocket science, but it's just being thoughtful in what you want for your children and then putting it in a legally appropriate document. And I don't want to dumb down per se what I do, but I think it's probably not, it's analogous to the work you have. I'm sure you've got patients that'll go on the internet to self-diagnose. And when they come in and they've got articles and stuff of what their problems are, you sort of chuckle and realize you've got a hangnail, ma'am. It's okay. You're not dying. So we see that too, but it's just a matter of understanding the simplicity of planning and then building it to make it work for your family.
Yeah, and I think you opened my eyes to certain things that I needed to do also with the kids, because I've seen families, as the families get older and things happen and husbands and wives pass away, and the kids come and swarm from different states and fight for assets. And one of the questions you asked me was, Jude, we're almost done with this. What happens to your assets, your watch, your tables and all that? How do you want that distributed? I'm like, what do you mean? He goes, yeah, you have to distribute it because you got 4 kids. So I don't even know if my kids know this, but I put in the will and with your help, if there's any dispute at the end of my life, then it needs to be donated. So the kids get nothing if there's any dispute. And I thought that was brilliant to add, because then, hopefully they won't dispute any of the assets that are remaining. But what it speaks to your point, having a plan for what happens so that there's less friction is great. It's great planning. So case number 3, older physician wants to sell their practice and exit. Kids are older. They're doing well. Last plan was done 20 years ago in another state. What would be your advice to that physician?
So, probably an established physician with that much experience probably has accumulated some meaningful assets. So I'm sure our conversation would include an estate tax discussion, which we can talk about as well. But as it relates to this, not ignoring the tax for a moment, I would treat this, at least at a basic level, the same as any other client. And I would ask the really basic question, like, what do you want to do when you're gone? And learn about at that point, you have adult children, so you can figure out where they're headed. But it could very well be, believe it or not, a simple estate plan if there's no tax planning. We think about where we are in our lives with young children. It's not appropriate to give them assets outright because they're younger and they can't legally own anything. But as our clients get older, it's kind of an interesting curve that can take place where an older client might say, I've got 30-year-old children who are well equipped and established and they're in a great place. So I want them to get assets outright. So that's an interesting starting point. I will pick at that. In fact, as an example, I work for a husband and wife physicians. They've done extremely well. They're very, very successful. And the apples did not fall far from the tree because their 2 children are likewise physicians who are quite successful. In fact, they're more successful than their parents financially. So parents are probably in their mid-60s. Their children are in their mid to late 30s. And so as a part of their planning, the question I asked was, well, where are your kids at? What are they doing financially? And they said, our kids are very wealthy. So the conversations changed a little bit. It was 2-part. One was, do they really need your assets? So we wanted to really study that. And they concluded that they didn't need them, but they wanted to leave assets to their children. So I instantly thought, well, what if your children got sued, or what if your children they're currently in happy marriages, but they were to get divorced in the future? What would that look like for your assets? And I asked them a question that they couldn't answer. So I gave them an answer, which was that their assets could be lost. So mom and dad die, they give their wealth to their children. And if their children get sued, it could be lost. And again, because they were both their children are surgeons, we were concerned, well, there could be an asset protection issue. So their planning actually says there's 2 components. The first for their children is that assets that they leave for their children will be held in lifetime trust. so that a child benefits, but a child is not going to lose it if there's a lawsuit or something to that nature. But then the other part was they said, we really don't think our kids need everything because of their success. So we're going to skip down and give some money to our grandchildren. They're not going to frankly need it because of their parents, but we want them to know that we love them and they're important. So they ended up incorporating their grandchildren into their planning. So we tend to see that as clients accumulate more wealth, as they get older, their families expand, and they start to really think about and assess where they want things to go and who's going to mostly benefit. What you added a little twist to the question, and it was the out-of-state comment. It's worth noting that all states will recognize documents from other jurisdictions. One possible caveat would be Louisiana, which is governed by civil law. So that's kind of the outlier, since it was owned by France forever, it seems like. Mm-hmm. So you could have some nuances there. But other than that, if a client brings a Georgia will or trust document to Florida, the Florida statutes are clear. We'll honor that document. But I usually recommend that my clients from out of state update at least parts of their documents so that they're governed by Florida law. And to me, that's kind of a common sense thought. It's, why would you want a medical directive, let's say, that's from where I'm from, Wisconsin, when you're in Florida, because the statutes are different? It's just kind of a disconnect. So we would incorporate the statutory change, but then really get to the heart of it. What do you really want to do for your children? Where are they at in their lives? And build a plan that does that. It may be that someone comes from another jurisdiction and their planning is accomplished. It's doing what they want. Well, then my goal is to make it Florida-based and get out of the way so we don't have to overdo it.
Yeah. And so one of the things that happened to me was that I had someone involved in my will. I can't remember which part of the will or trust or power of attorney was. He was out of the state. And you said something about the person has to be in state in order to be the executor, or what?
Yeah, Florida. So this is not the law in every state, but Florida's got a little nuance. In a last will and testament, we have a person who's called a personal representative, or sometimes the term's executor, but it's the person that would carry out a will, who wishes in a will. And the Florida statutes have this little nuance that essentially says you can name any family member, doesn't matter where they live, and they'll be qualified by statute. Or you have to name a Florida resident. So in other words, your best friend, I don't recall where he resides, but if he's not here in Florida, he can't serve. Now, with that being said, and without obviously revealing confidences of what you've done, leaving money in trust for a child, let's say, which is, it's not a will, it's a trust. So it's an ongoing tool to hold assets and pay those out over time. There isn't a statutory limitation. So we'll have some cases where clients come in and say, I've got this, I practice medicine in Kansas City and I've got a 30-year buddy I trust with my life. I want him to do everything for me. We will have to put the brakes on it with one role, which is the executor role, but he may be wonderful on a healthcare directive, on a power of attorney to manage daily or during life decisions, and even to manage a trust for a child after someone passes. But we would have that interesting limitation. I know that's not the law in other states. I think it's kind of an interesting nuance that we have here in Florida.
Yeah. So I know we've mentioned the word trust a lot, and without even defining it, I think you defined it through how you've discussed it. But what is the importance of having a trust? I guess, what's the difference between a trust and a will? Some people may not know that difference, and I know I didn't when we first started.
So it's interesting to know both of those have been around for centuries, but wills are really a starting point in estate planning. Last wills, let's clarify. A last will and testament is designed to create the legal roadmap for a disposition of a person's assets. It really only covers assets that are individually owned, that have no beneficiary designation. And the point of a will, or how wills would work rather, is that after I die, let's say, if I have a bank account in my name, we have to figure out how to get it out of my name and get it to my beneficiary. And so the will explains how that's done. But in all states, wills are governed by a probate process, which is essentially a judge overseeing the executor or person representative who will have legal authority through probate to collect an account that's in my name and then follow the wishes inside of the will.
So the will, you said, is of assets that you own personally. Does that include an insurance policy? Or it's a house, a car,
it's any individually owned asset that has no beneficiary. So if having a retirement account is an individual asset, but if you have a beneficiary designated on that account, the beneficiary designation it rules the day. So it doesn't come into a will. So the classic assets, you said is a home, your home, if it's just in your name, a bank account that's just in your name, a brokerage account just in your name. So if we have that type of asset, so an individually owned asset with no beneficiary designation, wills are very good tools to transition from a deceased person to that person's beneficiaries. The significant downside is that wills are governed by probate, that court process of retitling. And, unfortunately, probate has a bit of a bad reputation. But generally, I can tell you, because we do a lot of probate work, it doesn't have to be overly complicated, but it is definitely a process, which means it definitely takes time, and there's a cost element. And so as clients accumulate more wealth, we will oftentimes talk about a revocable trust, or sometimes we call it a living trust, as an alternative to a will. And the basic premise behind a trust is that if a trust owns assets while we're living, and I'll define who's in a trust in a moment, but if a trust owns assets while we're living, at the time of death, the transition plan is outside of probate. So in a typical trust, a revocable trust, there's three parties. There's the grantor who makes the trust. There's the trustee who manages the trust. And then there's also the beneficiary. So who gets the benefit? In a typical revocable trust, by statute, we're allowed to be all three. So I could create a revocable trust while I'm living, where I'm the trustee and the beneficiary. And I could then take my individual bank account and put it into the trust while I'm living. And so at the moment of my death, I can sort of mythically pass a baton of control to my wife as a trustee, who is unsupervised by a court to play out the trust plan. So it essentially is a substitute for a will, where we avoid a probate process to make things very efficient. Mm-hmm. When we think about what we started with a brand new doctor who is just out of school, I know medical school is unbelievably expensive, so they probably have a ton of debt, and their income potential is great, but they may not have a lot of assets. That type of a client, in my mind, doesn't need to spend money on a trust. They should just get a will. Let's cover the basics. And then as they accumulate assets that would be subject to probate, we can transition from the will estate plan to one that's centered on a revocable trust.
Yeah, that's so good. That actually clears it up in my mind as well. Maybe I didn't understand it as well when I was doing it. So I appreciate that. And so, what you're telling everyone here is that everyone needs a plan, regardless of whether you're a young doctor or an old doctor or someone retiring. And I think it's a smart way to go. And so how do we find you?
So I'm not sure how you put this out, but I mean, my website's trustedcounselors.com. I'm in Tampa, but I'm very blessed. I've got clients all over the state. Thank God for that. Nice. COVID's made things interesting because we've discovered that we can serve extremely well in a remote setting. I was a little concerned a couple of years ago, or a year and a half ago, when COVID kicked in, that we would have a challenge because, as you know, face-to-face time that we've had is highly productive. It is a wonderful way to serve, but it's not the only way to serve. So, you could certainly go to our website, give us a call. Our phone number is 813-254-0044. And I'm certainly happy to have a conversation at a minimum, just to give some of your listeners ideas of what planning could look like. As you know, I like to be very free with my time. I like to educate. I think that's really the secret to being a good attorney, is to think about how we educate our clients one client at a time so that they can make good informed decisions.
That's great. And we'll have your information also in the show notes. And I so thank you for being part of the Practice Impossible podcast. And we wish you a great success in your journey.
I appreciate that.
And it's wonderful to have you on our team and my team. And just also as a side note, Josh did include some of this information in our free course online. the learnaboutmedicareadvantage.com. So we thank you for everything you've done for us, and have a great weekend.
And before we go, Jude, as it relates to the course, I would strongly encourage your physician clients to take a look at the asset protection piece. Yeah. We live in an unbelievably litigious society. And while I know that all doctors will be diligent in their efforts, lawsuits happen. Mm-hmm. And so I think a good, smart asset protection start to a estate planning strategy is critical. So hopefully they'll have that. I know that information is available, and I'm certainly happy to have a conversation specific to asset protection planning with any of your folks as well.
Nice. Well, thank you again, and enjoyed having you.
Yeah, thank you so much.
All right, bye.